Mr. Chivayo, we welcome you once again to the interview. Question is in two parts. The first part is as follows. What does the principle of inherent jurisdiction entail? And B, give 3 instances where the inherent jurisdiction of the High Court is outstayed.
Thank you, Honorable Chief Justice. Good morning, sir. Inherent jurisdiction of High Court clearly entails that the jurisdiction is within, it is given, it's unlimited over all persons, over any claims, over any cause of action, civil or criminal. On the second part of this question, the jurisdiction of the High Court is not ordinarily outstayed because it's inherent. However, it may be outstayed in circumstances where a statute clearly indicates that such a jurisdiction is outstayed. I would give an example that if it's a labor matter, the jurisdiction of the High Court is outstayed in that the matter must be specifically referred to the labor court.
All right. The second question is also in two parts. The first part is as follows. Name 2 situations provided for under the High Court Rules 2021 in which an order or judgment of the court may be rescinded. B, what 2 requirements in respect of each type of case must a judge address before rescinding the order or judgment?
Thank you, Honorable Chief Justice. In the first part of the question, it is apparent in terms of Rule 27 of the Statutory Instrument 202 of 2021, that where a part has not been served with the documents or the process, the judge can decide such an order where it's proved that he or she would not have been served. The judge can equally rescind an order where he realizes that the order was primarily issued in error.
Is that all?
Maybe you may come again on the second part of the question.
You want me to repeat the second question?
The second part of
The second part,
Thank
it
you.
says, what 2 requirements in respect of each type of case must a judge address before rescinding the order or judgment?
The judge must be satisfied that the applicant was properly served and that he was not in willful default, and that is maybe very good grounds or prospects of success.
Question number 3 is in 3 parts. The first part, what do you understand by the concept of presumptive penalty? And B, what is the difference between a presumptive penalty and a minimum mandatory sentence? And C, state 2 effects the sentencing guidelines have had on the criminal justice system.
Thank you, Honorable Chief Justice. The first part, that's of presumptive penalty. It is penalty which is given within which a court must sentence an accused person. And mandatory penalty is what is ordinarily expected by virtue of a statute. So where a presiding officer decides not to go by a mandatory sentence, he must give reasons, because that will be influenced by circumstances. A good example may be that in terms of Stock Theft Act, mandatory sentence would be 9 years. And yet, on the presumptive penalty, there may be a recommendation. So, the presiding between the two, which one is appropriate? And where he decides to depart, he must give specific reasons for such departure. The last part of the question, with due respect, may you repeat the last part so that I accurately answer it.
Repeat the last part.
Thank you, Chief Justice.
State 2 effects the sentencing guidelines have had on the criminal justice system.
Thank you, Chief Justice. It is apparent that with such guidelines, they apply from the most junior level of the courts to the highest level, in that the aim is to provide uniformity. The second aspect is that there will be transparency. One is given a guideline within which he or she is expected to give a sentence.
Then question number 4 is in 2 parts. The first part, state 3 principles that govern the conduct of virtual hearing proceedings in the High Court. And B, what is the role of a judge in the adoption of a virtual hearing as a proceeding in the High Court?
Thank you, Chief Justice. It is apparent that the purpose for virtual hearing is that the parties do not meet. They deal with a matter electronically. That is, the judge will be in his chambers with other parties operating from elsewhere, like from their offices.
You are done.
Maybe you could assist me, Chief Justice, with the last part.
You want me to assist you again?
You're writing the question.
The last part is as follows. What is the role of a judge in the adoption of a virtual hearing as a proceeding in the High Court?
The role does not change in that it is always expected that the judge, whether virtually or in open court or in whatever circumstances, a judge is supposed to give a fair, just and impartial decision after hearing full matter. Thank you, sir.
Yes, thank you. I will now hand you over to the other commissioners for further questioning. Yes, TCJ.
Yes, thank you, CJ. Good afternoon, Mr. Chivayo.
Good afternoon,
I have one
Deputy
question
Chief
for you.
Justice.
Assuming you are appointed to be a High Court judge and you are presiding over a civil matter that I'm going to give a bit more detail on, what factors would you consider if a respondent argues that an application that would have been brought to the court should have been instituted through action procedure?
Thank you, Deputy Chief Justice. Indeed, a blessed afternoon, ma'am. When such a complaint or a request is brought to my attention, it's a clear indication that there is need to order. Either I order that the same application is converted into an action procedure where such documents filed must be considered with the parties filing further documents for an argument, because it's a clear indication that such a concern clearly indicates that there is a material dispute of fact. So where there is a material dispute of fact, the matter has to be dealt through adjusting of evidence. So I'll order that they proceed in terms of an action procedure. Thank you, ma'am.
Yes, thank you.
Yes, thank you. Yes.
Thank you, Honorable Chief Justice, and good afternoon, Mr. Chivayo.
Good afternoon, ma'am.
Yes, Mr. Chivayo, upon perusing your CV, it is apparent that you have got vast experience in criminal investigation, prosecution, and even great exposure to issues of human rights. Now, basing on that experience of yours, I would like to put just a single question to you. In your view, as a judge of the High Court, what should happen at the first appearance in court of a person who was detained by the police for more than 48 hours? I hope you understand. Thank you.
Thank you, Attorney General, Honorable. Once it's brought to my attention that there has been an over-detention, the Constitution is very clear on the rights of an accused person. It must have been, the detention must have been extended lawfully, but where it's not there, he is entitled to be released, to be immediately released, because it's a violation of fundamental rights of an accused person.
Just as a slight follow-up, Mr. Chivayo, in your view, this illegal detention you mentioned, is it a bar to the subsequent prosecution of the accused person?
It cannot be a bar, in my view, but it is subject to an investigation because there is a violation of a right.
Thank you very much. I have no further questions.
Thank you, Honorable Chief Justice. Mr. Chivayo, I would have two questions for you. The first one relates to the questionnaire that you presented or you filled and signed. Now, you agree with me, firstly, that the position of a judge requires someone who is concise and precise in terms of listening and responding to particular questions.
I do agree.
You agree. My concern really is where you were asked, the question reads as follows: what would you regard as your most significant contribution to the law and the pursuit of justice in Zimbabwe? In your response, you concentrated on what you would do in a position of a judge. When the question, in my view, required that you address what you have done.
Thank you, Commissioner. Maybe I could have missed the point, but it is apparent that for the entire service in government, I have been pursuing the justice delivery to the people.
Yes, my second question to you is as follows. There have been varying opinions amongst High Court judges regarding issues of testamentary dispositions of married persons. Is it possible for a married man to disinherit his wife in a will? And I want you to give us reasons for your belief.
Thank you, Commissioner. Yes, it is possible. I say so primarily basing my answer on Chigwada versus Chigwada, where following a plethora of decisions, anyway with a discord from High Court judges, some were interpreting the deceased succession, Estate Succession Act wrongly, wrongly so, worse now with the interpretation of where there is a will. However, there is a settled position now in the case I cited of Chigwada versus Chigwada, where the Honorable Chief Justice and other judges decided that where there is a will, it takes the day, because the author of the will would have decided in a will to disinherit a spouse. Therefore, the court cannot go against a will as long as that will was written in acceptable circumstances. So it means a wife can be disinherited where there is a will. Thank you, Commissioner.
Thank you, Chief Justice.
Yes, thank you. Yes,
Thank you, Chief Justice. Good afternoon, sir. Good afternoon.
Good afternoon, Commissioner.
Were you in the employ of the ZRP in the years 2010 to 2012? Or did you take leave of absence?
Very correct. I was a senior officer in the Zimbabwe Republic Police.
And the ZRP permitted you to be a special rapporteur for ZANU-PF in Kopak as a serving officer?
I was seconded. That's correct.
You were seconded by the ZRP to COPAC as a ZANU-PF rapporteur?
As a rapporteur for the constitution-making process.
Because your CV says rapporteur for ZANU-PF, that is why I asked that question. My second question is, what kind of legal cases did you deal with as a legal practitioner for the legal directorate? Any example of any one question that you dealt with in that capacity?
Thank you, Commissioner. I worked with the legal directorate at various levels, in that not only as a lawyer, but I ultimately became the director for legal services for ZRP. So I've been basically going to court representing ZRP in civil matters.
Is there any one case that jumps to your mind, for example?
Where police officers would refer matters before High Court on review, because the matter would have been dealt with by the Commissioner General on appeal. So they would always want to refer the matter to High Court, reviewing the decision of the Commissioner General.
What I wanted to know is if there is one particular matter that jumps to your attention when you look back over that career. Is there any one case that stands out that you can tell us about? No? Okay, that's fine. I was just interested. And then I noticed that you, according to your CV, and I believe it, you are a friendly and sociable person. Now, the life of a judge is a very lonely and unsociable one. How do you think you will make that balance and dissociating your social life from the office?
Thank you, Commissioner. I wouldn't know when you said I'm very sociable. I wouldn't know. But
your CV says it. It says you're a friendly and sociable person. I picked those words from your CV.
Thank you, Commissioner. That's in terms of ordinary interaction with people. But I am quick to say there is a code of conduct for any assignment. I must be guided, and I'm one such person who is very adaptable to a given setup. I will indeed manage to live within the expectations of a behavior of a judge.
Thank you, Chief Justice. I have no more questions.
Thank you. Yes.
Yeah, thank you, Chief Justice. Just one question for you, Mr. Chivayo. Is it possible for a statutory instrument to fall into disuse? If so, under what circumstances can a statutory instrument be said to have fallen into disuse?
Thank you, Commissioner. A statutory instrument may, like any other law, may fall into disuse where it has not been in use. And by virtue of it having not been in use, in my view, it falls out of use.
Thank you.
Thank you, CJ. Afternoon.
Good afternoon, Judge President.
Very well. You have a rich background in criminal law, having been a police officer.
Thank you.
Where are you now?
I'm now with National Prosecuting Authority.
Yes, and how are you finding it there?
It's fine. It's like historically, although I was a police officer, I was equally a prosecutor in public courts. Then police officers with the requisite qualifications would prosecute. So I was equally a prosecutor in public courts, though I was a police officer.
So please tell us why you've decided to become a judge.
Personally, I would take it that, having been a police officer, I was specifically looking at investigations of crime in various levels, as an investigator and as a director thereof. And that was very narrow an approach. Again, in my current position, and that I have been of a prosecutor, I'll be representing the state as a part to criminal proceedings. This time around, if accorded an opportunity to become a judge, I'm now looking at a very broad approach to handling a matter, getting the views from all the parties interested, and I have to adjudicate. So I feel, having been to those various narrow aspects of justice delivery system, being a judge now, I'll be looking at the circumstance of dealing or coming up with a decision from a very broad spectrum. Thank you, Honorable Judge.
Thank you.
Yes, thank you.
Thank you, CJ, and good afternoon.
Good afternoon, Commissioner.
So the JSC has implemented the IECMS, which is the digitization of our courts. From your experience or from what you have heard, maybe you can say 3 benefits of such a system to the NPS. Thank you.
Thank you, Commissioner. First and foremost, the integrated electronic case management system is paperless. So once it's paperless, it means we can be assured of the safety of uploaded documents, unlike if we're dealing with the old system of filing documents. Documents can be damaged, they can be stolen, and again, as a positive impact, cases can be tracked electronically. That forces whosoever is holding on to a case to promptly decide, because every part to the proceedings is able to follow, and they may always want to know, why are you holding on to it? So you are forced by the system to immediately decide and give your position immediately. If you are a judge, you are then forced to deliberate and adjudicate on the case before you. And the allocation of such a case is equally transparently seen by each part. They are able to tell that all our papers are now before Judge so-and-so, and they expect you to give a decision within a very limited time. Thank you, Commissioner.
Thank you for those responses. Thank you.
Good afternoon, Mr. Chivayo.
Good afternoon, Commissioner.
My colleague earlier on asked you about why you wrote on your CV that you were a rapporteur for ZANU-PF during the compact constitutional making process. Now, as a judge, you are supposed to appear to be impartial, both in appearance and it must be real. If 2 cases are brought to you where politics is involved, which route would you take, and what perception will the public think of you?
Section 165, it's very clear, it's in the Constitution. It gives guidelines on what is expected of judicial officers. And it is very specific that as judicial officers, we are not supposed to take part in any political activities, either by attending meetings, by accepting donations, or in any manner or so manner. We are not supposed to be partisan. So I'll go by that, and I make an undertaking that I'll go by that, because it's a constitutional obligation, and as a judge, I must be guided by the law and the people of Zimbabwe.
Thank you.
Thank you. Thank you, Chief Justice. Good afternoon, Mr. Chivayo.
Good afternoon, Commissioner.
Yes, your CV and personal attributes. Right, you say that you are able to work under pressure where deadlines have to be met. And my understanding of a deadline is that you already know when something is supposed to happen. and it has to happen by that time. And when you're saying yourself you're able to work under pressure, how do you then leave yourself to then, I don't understand how pressure is coming in a situation where there's a deadline. Is there a question of not being organized, not being able to manage your work properly, such that you find yourself under pressure?
Thank you, Commissioner. When we talk of working under pressure, it's unlike when one is allocated one matter or one aspect with a deadline. You may have many of cases with deadlines. That's the voluminous or the volume of the work itself will force you to work under pressure. And if all such work has deadlines, it means you have to put an extra effort to make sure that you deliver within the given time limits. We may be all aware that you can't just work as you wish. In any given organization, there must be timelines within which work must be done, standard time procedure. One is guided by that. So it's not like you are given one particular assignment and then you are guided by a deadline. You may have, like even in the example of being a High Court judge, I may be seized with many cases. I must decide within a given time. So it means I must give myself extra time, more effort to ensure that I deal with such matters within the expected standard. Thank you, Commissioner.
Thank you, Chief Justice.
Just one question. You seem to have been involved entirely with criminal matters, investigation of criminal matters and so on. You have not been exposed to issues of civil procedure, civil law. Is that correct?
Thank you, Chief Justice. It's not a correct position.
What is it?
The correct position is like what I alluded before, that apart from having been doing investigations, I was also with the legal department of ZRP, specifically dealing with civil matters and representing ZRP in civil matters. So I'm equally...
You were representing the ZRP in the High Court, did you represent it in the High Court on civil matters?
Yes, Chief Justice.
Is it? What kind of cases were there?
I indicated before reviews of police officers who would have challenged the Commissioner General's decision.
So these are administrative matters?
Disciplinary matters, but
disciplinary administrative decisions being reviewed, and that's how you understand them. Are you understanding what civil matters that we are talking about to mean administrative decisions of the Commissioner General against the police officers?
Thank you, Chief Justice. It is a disciplinary matter, but brought before the High Court as a civil matter. A good example would be, in terms of the civil procedure, a part is expected to file documents within a certain period. And if you don't file, like opposing documents, if you don't file them, you are barred. Default judgment is given. So all that, in my view, is civil procedure, but I'll take it from a disciplinary case, but I'll be applying principles of civil law, civil procedure in the High Court.
Is that all the type of case you consider to be in the category of civil litigation? That's all. Coming into court, challenging or opposing applications for review by junior police officers who have had decisions against them by the Commissioner General. Is that all? That's the kind of work you are doing?
It's not all. The Ministry of Home Affairs could equally be sued by any individual who is or may have a claim against the Ministry of Home Affairs, especially where an abuse is expected.
Oh, yes, that's what we are trying to find from you. Did you represent in any case the Minister of Home Affairs in that category?
I did.
Where? At the High Court?
At the High Court, yes.
When was that?
The way we were going to High Court has been that we go with law officers.
When? How you were going? Just tell me when.
Before
when you in particular as a lawyer in the police department appeared at the High Court to represent the Home Affairs when it is sued, which has been sued for whatever purposes. Did you do so? You said yes. When?
From below 2015.
2015?
Yes.
What was the case about?
The cases were like civil suits, like I've mentioned.
No. Just give me one case. What case was it about?
I dealt with many.
So you can't remember any one of them?
Off the cuff, I cannot remember, but I dealt with many.
You were a representative, a lawyer representing a client, and you can't remember any case, any factual setup to tell this commission so that we can measure your ability to stand up in the High Court and appreciate the rules of procedure, civil procedure. You can't remember. If you can't remember, that's fine. Is that what it is?
I'm honest and candid in that we'll be having the Attorney General officers. So we'll be accompanying them. Obviously, I'll be having
that is exactly what, that's the reason why I was pressing you.
Thank you.
You were not appearing. That's why I'm pressing you. You were not appearing. It's lawyers from the Attorney General's office who are appearing. But perhaps with your assistance behind them. That's not appearing. Is that correct?
I'm guided, Chief Justice.
No, is that correct? I don't want to guide you. Is that correct?
Our names will be asked and will be registered.
No, please. You are before a commission, serious commission. Is that correct, that you are not appearing to represent directly in litigation the Home Affairs?
In the circumstances, it means I was not.
You were not?
Yes.
Yes, I think so. Anyway, thank you. Right, thank you. We have come to the end of your interview.
Thank you, Chief Justice, and the panelists for according me the opportunity. Thank you.